practice, and what as accountants our role as financial neutral is. And it's changed. The actual our services we offer in this area are very different. So we just thought it was a good opportunity to talk about financial neutrals in this space. So very pretty pictures of us. All of the slides will come through afterwards in an email. So today's more about having a bit of a listen. So the areas we want to talk about today is the background in relation to collaborative practice, very briefly. What is collaborative practice? The role of the financial neutral and who that financial neutral may be, and then looking at some case studies on cases we've done. One's a couple of years old, but it's just a really good example of some of the areas that can be done in the collaborative space. And also another one is a little bit of a more recent complex case. So to kick it off, Anita, tell us about the background.
Okay. Well, collaborative practice, it all started back in 1990 with a letter from Stu Webb. He wrote a letter to the Honourable A.M. Sandy Keith, a Justice of the Minnesota Supreme Court. Stu was a bit jaded and a bit burnt out by the traditional method of dealing with family law matters, and he thought that there must be a better way to do things. And he came up with the idea or a proposal which was really centred around removing the prospect of a trial and all of the parties negotiating and just going towards a settlement process rather than that usual go to court and battle it out that way. If a settlement wasn't able to be negotiated in Stu's idea, then all of the parties, the lawyers, any other advisors were to retire and were no longer able to participate in the process, and a whole new team was appointed to represent the clients for the adversarial process. I guess in that fashion or in that way, it gave the parties the incentive to reach a settlement so they didn't have to go back to square one and start again. So all of the people involved in that process were working towards a settlement.
Remember that letter, he also talks about in that letter that wouldn't it be different if lawyers could work together to actually help resolve the client's matters, plural, as opposed to just advocating for their client.
Yeah, just for themselves, yeah.
So it was quite a different approach.
A team approach.
Mm. A collaborative approach.
A collaborative approach, definitely. So what exactly is collaborative practice? So rather than us sit here and talk for another 5 minutes, we thought we'd just play this short video from the Australian Association of Collaborative Professionals website.
Think of the word relationship. Relationships are central to our daily life. When a relationship is expected to last, people may form contracts, associations, partnerships, marriages, and when these relationships end, there is a lot involved in splitting up. Separating at the end of a relationship can be a long, exhausting, and painful process involving emotional conflicts and legal disputes. Taking those conflicts and disputes into a judicial process is like declaring war, where the objective of each of the parties is total victory. Take the classical example of a divorce, which traditionally involves, on the one hand, an emotionally distressed husband and a lawyer armed to protect his client, and on the other, an emotionally distressed wife and a lawyer equally armed to protect her client. In the centre of this conflict, a fight about the fruits of this relationship: a home, investments, a pension, and the most precious treasure, the children. And to complete the scenario, a judge who, despite the best preparation, does not know the people involved, nor the unique needs of each family. He is given the power of deciding what will happen to everyone and everything in dispute. Too often, the result is that everyone loses. Children grow up in the middle of battles in the courts. Parents spend their savings on professional fees and costs, and the family ends up needing psychological counselling to overcome the trauma of a contentious divorce. The moral of this story is that courts are no place to bring the normal disputes involved in ending a relationship. But there is a better way, a method of resolving issues associated with separation and divorce without recourse to the courts: collaborative law. It is a method which recognises that the end of a relationship is a human experience that is best addressed by a humanistic process for resolving conflicts, Disagreements between the separating parties are resolved by an interdisciplinary team in a collaborative approach. In a collaborative divorce, everyone works together, constructively, face to face. Husband, wife, collaborative lawyers, and if necessary, mental health professionals, the children's advocates, financial advisors, all work together in a structured process with the goal being consensus for the benefit of the family. Parties and lawyers sign an agreement whereby they undertake not to take legal action, but to work as a team using constructive dialogue to build solutions and reach agreements. It is a win-win situation. The process is faster, more economical than litigation, based on consensus rather than power, places value on human relationships, and unclutters courts. Collaborative law was born in 1990 in the United States from the inspiration of a lawyer tired of working in a stressful mode and fed up with the destructive battles involved in divorce-related conflicts. Today, there are highly trained lawyers, mental health and financial specialists working collaboratively in disputes in the field of family, civil and commercial law. There are more than 22,000 collaborative professionals worldwide, including in Australia. Whether you are a potential client or a professional, you are invited to consider collaborative law.
That definitely showed us the team environment working towards a common goal. So here's a little diagram of how a collaborative team and how the process may work. So we start with clients, A and B. They each appoint a collaborative lawyer to represent them in the process. All of these parties sign the participation agreement that we mentioned before, that where they agree to work towards a settlement rather than the court process. That's the disqualification clause, where we must retire if we don't get to the settlement step. Then the interdisciplinary team can be assembled to assist all of the parties and the lawyers. So we have the coach who oversees the process if necessary, the financial neutral who is appointed to deal with the financial dealings of both parties. Then we can have other specialists if we require them. We can have a child specialist, a real property valuer if we need to value some real estate, a mediator if the parties can't reach the agreement themselves, and any other specialists who may help tie the whole process together. The parties enter into interest-based negotiations, so it's all about working towards the goals of each party. Why do they want to achieve? Why does one party want to achieve something? Why do they need a settlement to go a particular way? And just trying to deal with those interests of each party. It's important to remember the clients control the process. Often they're the ones that reach the resolutions themselves, just being guided by the various team that have been put together to assist them with that process. There's regular face-to-face meetings, so they're scheduled at various time spaces throughout the process. It may be 6 weeks, it may be monthly, depending on how long it takes to get each step happening.
And importantly on this point, very few letters are written. So it's not done in writing, it's not done at 20 paces. It's face-to-face meetings, whether it be in a meeting with everybody or whether it's being a lawyer with a financial advisor or other professionals. In an offline meeting where you're doing work to bring back to the main meeting, but all the decisions are made in the meeting together.
Yeah. And those meetings have the agreed agenda. So each meeting may deal with a particular issue, and the agenda is what is discussed in that meeting. And then the parties go back, have a debrief, and work out how that meeting went and how they proceed, if they need another meeting or is that issue resolved. And everything happens within the meeting. As John said, no letters exchanged in between. It's all discussed at that point.
So clearly this process as a mechanism is very different to the normal litigation process, in that the clients are controlling it. The clients are being identified with help from their lawyers and their other advisors, what their interests and their goals they're trying to achieve. And then everyone at the table is actually signing an agreement to try to assist the clients to actually achieve as close as possible each of the parties' interests and goals. So it is a very different focus in how it actually moves forward. Importantly, also as part of the participation agreement, there are agreed rules of procedure or guidelines on how we'll interact. and they are talked about at the collaborative table and with everyone there and documented as such. So in that first meeting with everyone there, those guidelines are talked about, the interests are talked about, what everyone's trying to achieve is being talked about. So down the track, if we deviate from that, we've got something to come back to. And the clients say at the outset what they're trying to do and why. It's easy to bring them back to that point if actually things get a little bit hard.
Okay. So the role of the financial neutral. So a financial neutral can be an accountant or a financial planner. They must be collaboratively trained. They collate all the information in relation to the matrimonial pool, budgets, analyse expenses, if necessary, business valuation, and discuss the tax implications of that valuation on each of the parties. It can be an educational process, educating the parties on, do they actually need a particular amount of money to survive for the rest of their life after the marriage ends. Generating other options for the parties and working out a pathway for each of them to achieve those options. Forecasting for them, and most importantly, testing for reality. Can this actually be achieved if we go down that path? So the next...
You can see there that the role is quite broad, and particularly if the financial, whoever that financial may be, their role really is dependent on what the actual matter needs. And it's the table that actually, collaborative table, that helps decide that. So the clients ultimately are sort of saying, all right, we understand this is required, how are we going to achieve that? And you'll see there on the third point there, collates information, matrimonial pool. You've got a financial person putting together essentially the net asset pool, putting together the expense analysis, what does actually lives cost? So from an educational viewpoint and from a speed viewpoint, one person doing all of that, providing that to the parties and explaining why and identifying any issues with that pool, it's very efficient. And usually we actually get to that point within a couple of weeks of actually starting. And everyone signed off on the pool. How do we move past that point? What are the next steps? So it really is a different process to work within. It actually is really, really challenging in doing it. This work, from our point of view, we're forensic accountants. Most of our stuff that we do, we get thrown a scope, we complete that scope, we hand up our report. And it's very cold in that we can hide behind our reports. In the collaborative process, we don't hide behind anything. We don't get a scope at the outset. We help design what that scope is. We come back saying this also needs to be done, so redefine our scope. We usually don't produce a report. We actually deliver our findings in a room with everyone there. So it's very live, and questions come back to you very quickly. So it's quite confronting. And one thing that was really confronting with me, you get all the emotions of the matter in the room with you, which as accountants, we don't deal with any of that stuff. So it's really a different process to us to actually work within. So why do we do it? It's really quite the skills needed. It's constantly challenging, constantly pushing, constantly trying to resolve different ways forward. Why do we do it? Because it actually allows us to really add value in what we're doing. And that's probably the biggest part of it, actually leaving a matter and actually saying, we did good today. And that really, particularly from my point of view, I'd say for myself, that's the big thing, is actually finding a little bit of soul in what we do.
Yeah, helping somebody achieve what they're trying to achieve, rather than just giving them, here's a report. Yeah.
Which rarely do anyone really understand, or do you take the time to read what we're saying, or you just turn to the executive summary and start arguing over the answer.
Yeah. I'll just brush over this one, the 4 pillars of collaborative practice. So we've discussed the participation agreement, communication, particularly important because it's all interactive and live, being transparent, teamwork, and the word on those hands down there, trust. It's always important in any process like this.
Now, if you compare this again to the normal litigation process, you'll see that it's a little bit different. Each of those 4 pillars are really important. Participation agreement sets out how we do things. Communication, it's open communication. It's very transparent from our point of view, from everyone's point of view. What goes on, it's all on the table. And probably the biggest thing, and probably the biggest plus from my point of view particularly, is actually working within a team. We're no longer this cog on the side. We're actually part of the whole process. And an absolute educational experience. It's been an absolute privilege working with a lot of the practitioners I've worked with, to learn from them how they do things, why, and to add to our own skill base.
We discussed earlier the interest-based negotiation, and I guess it comes back to communication. So in these pictures, we can see an orange. It could be a piece of orange, it could be a peel, it could be the juice of an orange. So if we were to be doing or working in this area and somebody or two people are arguing over an orange and you just can't be bothered dealing with them, so what do? You cut the orange in half and you give one person one half of the orange, you give the other person the other half of the orange, you go, there you go, problem solved, off you go. If we were to actually sit back and ask one of them or both of them, why do you want this orange? And one of them says, I want the juice because I'm making a cake. And the other one says, well, I wanted the peel because I'm doing an artwork and I want to make the peel come off in one piece. And you've just cut the orange in half thinking you've solved the problem. In reality, everybody walks away unhappy because there wasn't enough juice for the cake. The peel's cut in half and it's ruined. So no one wins and everybody goes away unhappy. But with interest-based negotiation, if we listen and we work towards a goal, we could have squeezed or could have cut the peel off and given the one person the peel, they could go and do their artwork, squeeze the juice out of the orange, and the other person has enough for their cake. Everybody walks away happy.
What's a practical example of that?
Convert this across to what we might do. You go into the negotiation table and one party says, well, I definitely want to keep the house. Well, why do you want to keep the house? I want to keep the house because it's close to the children's school and I don't want the children to have to move away from their school. Or the house might be in a particular area where the person has all their friends, and the other party may not have such an attachment to that area, so they may be happy for that house to be retained by party A, and the other person is happy to go and move elsewhere.
Mm-hmm. So the big thing there is interest-based negotiation is all about asking the why, moving them from a position, I need the house, I've got to have the house, to the why do you need to have it, and then maybe there's a different way of structuring it. So if the most important thing was the local school, being close to the local school, well, could we rent a house or buy a house also in the area that's at a lower cost? Yep, that'll fit the bill. Or it might be we could do something else with the house that actually suits both their goals, as opposed to I must have the house, therefore the other person cannot have the house.
Yep.
And try to actually, from looking at broader, if we downsize the house, we can actually have more income producing activity or investment. Everyone wins. So from that point of view, again, why?
So how do we compare the traditional process to the collaborative process?
So it's really looking from our point of view, a forensic accountant. First, we're a single expert under the traditional approach, or a financial neutral under the collaborative approach.
So under the traditional approach, our responsibility is, or our duty is just to the court. In the financial process, it's outside the collaborative process, it's outside the court process, so that duty is not there. An independent expert, their duty to the court overrides any duty to the client, whereas a financial neutral, their duty is to the parties jointly. An independent expert must comply with all of the court rules. Again, financial neutral, we're outside the court process. In both processes, the professional regulations of CA or CPA or any other professional body, you must comply with those irrespective of which process you're under. As John said before, traditionally you would deliver, a single expert delivers a written report, whereas the collaborative process, it's done within meetings, and the outcome of the investigations or the outcome of what we work through for the parties is presented at those meetings, educating the parties in relation to what we come up with in those workings. Again, John mentioned before, the instructions that we receive, we get a scope, we work within those instructions and the traditional single expert process, and we're bound by those instructions usually. Whereas in the collaborative process, those instructions are ever evolving as the negotiations are worked through. So there's more interaction, I guess, more ability to work things through rather than just have to deal straight down the line and work to a set of instructions.
One of the things that really has hit me over the last, whatever it is, 13, 14 years of me doing this work, is that the education focus. You know, we quite often ask parties to make decisions in relation to matters they don't understand. We do a valuation, we produce our report. It's a 30 to 50 page report with all of our terminology and spreadsheets and numbers in there. Now, for someone who actually understands business valuations, it's all there. We under all our prescribed guidelines, APS 215, APS 225, we tick all the boxes. We do a good job. But rarely do people fully understand what we're doing. And the clients tend not to. And they turn over and say, there's a number. What are they gauging that against? They don't understand what we're doing. They don't understand necessarily what the real issues are and what the variabilities are. They don't necessarily understand risk or what the cash flow means in what's there. Under the collaborative approach, we've got a real focus on education. Knowledge is king. We need to be able to actually have people understand what we're doing and why and what the key drivers are, or we've failed in what we're doing. We've really got to actually empower our parties in relation to understanding where we're at, why we're doing it, what they need to know moving forward to make a decision, which is what our first example is about a little bit later.
I think we might be up to
But a little bit later might be now.
That might be about now.
Okay, there's bonus points if anyone actually writes in to say.
Doesn't count in the real.
I think you've got a comment there. I'm assuming it's for you. If you can actually work out where these photos are, there's bonus points. So the first example, so we're going to do two examples now. One's a fairly modest pool, didn't have a business, and the second example is quite a complex pool. So the first example, John and Sue, they're both in their late 50s, adult children. They live a fairly modest life, modest pool and lifestyle. John's full-time government position, has been for a while, holds a fairly high position. Wife is also working part-time administrative role. They've got a house and a mortgage, a reasonable level of superannuation, and then some rats and mice in the other assets and liabilities. So step one is sort of saying our role, where does it actually fit in? So the financial settlement process, we're involved in the financial side. So the financial side ultimately is twofold, primarily assisting in the coming up with essentially pathways for the division of the actual property pool and moving forward, but also trying to look at from a reality testing point of view, will they actually have enough money coming from that pool to live? Or are we actually just ripping the actual pool apart, sending them on their ways and they can work that out later? So our role normally is defining the pool, considering the cash flow that's currently being generated by the pool and other employment, coming up with a different pathways to options to actually divide the actual property pool. Once we've actually come up with several, and again we'll show this shortly, we look at looking at our primary pool. The parties will agree on which way they actually want to explore. We come down to one. We work with the pros and cons. We come up with an answer. With the parties come up with an answer. Reality test that pathway, and if there's any issues, we essentially just tinker and test. What can we actually change to make it work better, and then agree on that outcome. But keeping in mind always that under the collaborative process, we're actually working with the parties' interests and goals. So when we're actually reality testing a pathway, obviously from a point of view that we're reality testing to make sure it works, but secondly, we're reality testing it back against the interests. What did they actually ask us to do at the outset, and have we actually kicked those goals? If we haven't, we've got to go back to them and say, look, what you've agreed to is actually deviating from what you initially told us you wanted. Are you happy with that difference and why? So again, each time it's going back to them and actually help facilitate the thought process for them. I think now we're actually coming up with the first spreadsheet. So the financial people online, we're doing our numbers. So as I showed before, the step one is to actually define the pool. And that's exactly what we've done here. So this is the pool we put together. Fairly simple pool, so it didn't take long to put together. We've got residential home, in this case here, we instructed the valuer, and that's quite often what happens in this process. The financial takes over anything with their financial side. So we instructed the valuer, they came in and valued the property. There's some debt against the property, various bank accounts, some odds and sods, a couple of shares, and some personalised car number plates. Sue has a car, fairly old car. John has a car through his work, a novated lease. They've got personal possessions. They decided not to actually include, beds and knives and forks in the asset pool. They could divide them separately. They also had flyby points and Qantas frequent flyers, which interestingly became a big part of the outcome and how they actually divide those, should they be divided. John had a 6 months long service leave owing to him, which again was a really big part of the actual outcome. Then they had superannuation, a big chunk of it being a defined benefit, which you don't often see anymore, and the rest being accumulated side. Coming up with a pool of just under $1.6 million. We also looked at the income levels, which again was important once we actually see the next little bit. So we can see that John earns an income after tax. This is a couple of years old now. After tax, about 110, and Sue had a salary of about 14, plus a little bit of super going in. So we did the pool, and at the same time putting the pool together, we asked the both of the John and Sue to have a look at their own finances. How much does it cost? They believe that's going to cost them to live going forward. So we gave them a fairly simplistic spreadsheet. So for John was renting. How much it would cost? He just fills that out. So each of the numbers they put in there, it comes through to a cumulative side. Sue gave her answers to this. She went through everything, came up with her lifestyle was going to cost about $75,000 a year. Now, importantly, that's an after-tax position. John, same exercise. Sue was still living in the house at that stage. John was external. She came up with $76,000. So when you actually combine each of their positions, their cash flow positions, we came up with $152,000. So we compare that back to how much money they're actually taking home. Obviously, that $150,000 is more than actually their income, their after-tax income. So problem one, we know cash flow is going to be a big issue here, which obviously from a matrimonial viewpoint, often it is a big issue. My anecdotal experience has been that families tend to live within their own cash flow constraints. So once they actually, you set up a lifestyle, mum and dad separate, we start running two households, the expenses can increase up to about 50% of what it was previously. So where we had 100%, where for these guys it worked when they were together, when we actually divided it up, we actually spent more money and it was more than they were actually earning, which is, like I said, often the case. So there needs to be some sort of reality test moving forward. Separate households aren't as efficient as one whole household. So keep that in the background. So net assets we have here. We've done the net asset pool. We've done the expense analysis. The next thing is actually looking at options and pathways to separate the property pool. So to do that, we actually use the same spreadsheet, and essentially we put two columns, John and Sue, who's going to get what, and we look at different pathways to do that. Now, pathways, we always try to come up with at least 3 pathways, usually for both husband and wife. So we actually have 6 to choose from. Because we're involved in doing that, obviously we're poking and prodding as to where that actually goes and asking questions. There usually is a pathway that actually crosses over. In this case here, there was. And the pathway essentially looked like the house actually got sold. Sue acquired a unit, took debt out to acquire the unit. And this is part of we knew different things in the collaborative process. John guaranteed the debt against the property. They split everything else as it was. All of the accumulated benefit component of the superannuation went to Sue, and John took the defined benefit amount, but it was split now and to be paid later when John retired. From John's point of view, we then actually did the reality testing. And I don't want to go through each of the individual lines, but we actually took how long is he going to work for with this pool, how's it going to work? In this case here, of his salary, that he took out. He paid maintenance to Sue, which allowed her to meet the mortgage repayments and have an amount to live on top of the actual salary she was receiving. And he also had enough left over to start accumulating a bit of cash. So from his point of view, while he actually continued to work, he started increasing his asset base with cash, and also his superannuation was increasing by a multiple because of the defined benefit fund. Once he retired, and this is where the interesting part came in, once he retired, which was actually 6 months before he completed his employment, because he had the long service leave, which allowed him to write it out, and that actually had a multiplication effect on his superannuation once again. When he retired, the amount of the super defined benefit fund that was split went across to Sue. Sue was able to repay the mortgage, and this was all part of that plan. And we can see that from John's point of view, he relied on his cash holdings on retirement until the cash was exhausted. Then he relied on his superannuation. And we can see here that at age 82, he still had $500,000 in super, and he was very happy with that. He said, I'm right. Yes, I'm not getting the same income that I thought I would. However, I've also repartnered, so I'm not actually paying the rent of the $25,000 a year that I said I would be paying. If this all goes well, I don't need it. I understand that Sue needs it as well, so I'm good. He ticked off his side. From Sue's point of view, a little bit harder because she's relying on amounts coming in and not earning a great deal. So she continued to work for a period and then retired. She had the mortgage to repay. However, that got repaid on superannuation, and then she's relying on her super to survive, but she's still got the unit in the background. So we can see from her superannuation is fully exhausted by age 77. And then that actually goes into the negative. So at age 77, she's running out of money, but she still had the unit. So from her point of view, she knew she'd cash that in, and she was going to actually, ultimately, she didn't actually buy a unit. She actually built a annex to one of her daughter's houses, and she was happy with that. And one of the other big things that she wanted, I said this before with the frequent flyer points, is that one of her goals was to travel once a year. Now, from this income, she couldn't. But from the frequent flyers, that actually allowed her a level of travel that she could exhaust over time, because John had a big travel with his existing government position, so he had a fair few frequent flyer points there. So again, that allowed, by structuring it differently, that allowed her to achieve her goal. So at the end of this, it worked. They had a very moving speech to each other in the last meeting, which I'd never seen before, and it really was moving, and it worked. And the feedback a couple of years later, which again, this type of process does actually quite often allow for feedback to come back a few years later, everything had worked, and they were both actually living lives, and funny enough, were friends and still very involved in their daughters' lives, even though they were adult children, and the grandkids coming through. So again, this was one of those success stories. This process does not happen every matter, but it is quite often a great way of reality testing the outcome where things are a little bit more marginal. So I'm just reading a couple of the questions. So Robert, thank you. Is it permissible to act as an independent expert after having engaged in this process? It's a really good question, and prima facie, with the participation agreements there, we act for this process, and if it goes further than this process, or this process ceases, it doesn't work, and it goes to litigation, my principle would be no, and that's what we agreed to in the actual participation agreement. There are instances, though, with both parties, if they agree, that they both ask, we've done the valuation, can you actually use that valuation litigation? If both parties agree and the expert agrees, potentially there's a way forward. But just keeping in mind that under this process, we're acting for the parties, not for the court. So there's things that we get exposed to, we wouldn't ordinarily get exposed to. So do you want the actual financial person doing work down the track? Maybe yes, maybe no, but just keep that in mind. The second question, how often do court proceedings follow attempts at the collaborative process? Another really good question. When we started I got trained back in 2008, and my first matter was about 2010. and that's really when it sort of kicked off in Queensland. The processes then, we tried to follow the American style of collaborative practice. What we found is it was really clunky with the Australian culture. And since then, we actually adapted how we do it in Australia. We actually, funny enough, has actually adopted a very similar approach, although not realising at the time, as Canada. And since doing that, early on, I was probably 20% of the matters were struggling to actually get completed in this process from what I'd actually been exposed to. Since about 2012, 2013, I've seen one matter not go through, and that was back about then. Nothing since then has actually, in my mind, hasn't settled with collaborative. Because if it's run correctly, the parties are invested, and this process, for the right parties, and it's not for everybody, but for the right parties, this process will give the ability for them to actually have better outcome, whether it be financially, personally, with the kids, but a better ability to actually meet their interests and goals, as opposed to the court process where it's very clear cut. The judge is making a decision and he makes it based on what he thinks is correct or she thinks is correct. So two very good questions. So again, the financial settlement process, you can see we defined the pool, worked out cash flows, options for splitting, determine a primary way forward, reality test, tinker and test. The second example, a little bit more complex. So the accountants in the group here will actually see that this is really where the sort of forensic side comes through. Jock and Nancy. I see no one's actually tried to, worked out where these photos are yet. Jock and Nancy, interesting in the four-wheel drive industry, hence the photo. Early 50s, again, adult children. Adult children tends to just change some of their interest and goals. It tends to be, instead of actually having stability for the children, care of the children, shared care of the children, being involved in the children's lives, it moves more to being able to have a relationship where we can actually be involved in the children's lives without conflict. So again, it doesn't really change the financial side of what we do, apart from, again, cash flow, I guess. They had a large niche manufacturing business, and although it was expanding rapidly, it was a fairly simple business, and they outsourced a manufacture of one single product, and they had two major clients, but had done very well. Highly profitable, big IP issues. Both were actively involved in the business, and relatively, in the scale of what the business was worth, relatively little net assets outside the business. Some of the issues in this one: the business had experienced a high level of growth. I said before, one product, two primary clients. The majority of the business value rested in goodwill and, to a lesser extent, value of IP. They disagreed with my answer. I came out and valued it, and the husband said, "I don't think it's worth that much." Now, as it turned out, it wasn't the husband who necessarily thought that as much. He was worried about the number, but it was his advisors who thought, we question whether you'd actually get that. And that was okay, because we can actually sit down and talk about that as well.
And John, is that part of the meeting you had with the clients? You got to sit down and discuss that valuation in a meeting and actually show them in real time?
Yeah, look, very much so.
Yeah.
And the way it normally goes, we work with one client, then we'll work with the other client, and then we present it again in the meeting and talk about it. But just because they disagree on something, that just has another problem to solve. It doesn't mean it's off the table. And that's exactly what happened in this instance. Business value was the primary part of the well and truly majority of the pool, the asset pool. Huge Division 7A issues. We're talking about 6 odd mil. Significant unrealised tax costs. And again, I'll show you that shortly. The husband, Jock, he was the CEO. He was big picture, business orientated. Essentially, he was the guy who had the ideas and wanted to play. Wife Nancy was the detail person, ran the office and ran all the accounting side, and was a person who actually did the test checks, made sure it all worked. As a team, they were tremendous because they tackled everything from a different approach. However, where we'd actually got to now is Nancy was in the office all the time. Jock would not be in the office at all. So he was avoiding the office and therefore avoiding work. It was a forward driving type business. He would just go out on trips. And so all these things weren't happening, and it affected the employees. If Nancy left the business, now keep in mind she was the office person and Jock was the main drive from a business viewpoint, it left a huge hole in the business. Jock's big picture approach would have been a disaster in this business, but if she leaves, what happens? Through the process, or the start of the process, Jock was very, laissez-faire about everything. Yeah, it'll be right. He became, when he started seeing the numbers and where they were standing up, he started getting really risk adverse and concerned that it wouldn't work. And the last one again, Jock avoiding the office, he would just disappear. And when he disappeared, he'd go on he'd organise a four-wheel drive filming trip, which would take a month. He'd just disappear, and he'd decide the day before. So employees had a lot of trouble actually catching up with him. So from numbers viewpoint, the actual structure that was there, the business operated through a unit trust. Recently, it had a separate IP company for the actual IP to be transferred to, but at the time of actually looking at it, hadn't been completed yet. Family Trust owns both of those. Has a corporate beneficiary, which used to be the operating entity many years ago, hadn't held the equipment. Now is just a corporate beneficiary. So every year being a unit trust, the profits that were millions, the profits being derived would automatically go to the family trust, and the family trust would automatically flow it through to the corporate beneficiary, and the monies would be loaned back to the unit trust. So it had all of these Division 7A issues that were actually cropping up. They also had a self-managed super fund on the side, which used to hold the business premises, but since then they'd moved out of that premises and ultimately sold it. So it was just cash sitting in there. Net assets that are there. Now I've split it up in this way. So I'll just quickly go through all the different entities that were there. There's going to be small for you to actually see. But you can see the actual growth of the business has been quite strong, and the forecast moving forward we're going to be even stronger. We've got, when we talk about being a consolidated position, if I can make this work, we have the unit trust, the operating entity, and then the IP entity. So actually the IP entity was being paid a fee coming from the other entity. They also had the corporate beneficiary that held the equipment, which incurred certain costs. We consolidate all of those. From a valuation viewpoint, without going through, there's 30 spreadsheets behind this, but for simplistically, we value the business on a going concern basis, including the IP, came up with $12 million, excluding the IP being 10.9. We also valued the IP on a different basis and came up with a separate value, but the business excluding the IP was about 10.9. So we come back to the net assets. Valuing the family trust, which held the unit trust and the IP entity, they came in at about 9.3. Now, interesting, you'll see there we've got business sale, no business sale. I'll come back to that shortly. So we've got the $9 million in there. We've got the corporate beneficiary was valued about 5.5. Now, the main amount of that value is the actual loan accounts that the unit trust ultimately owed. There's a few corporate beneficiary bits and pieces in there. Now, the tax on the Division 7A loan came to 1.3. Should that be included or not? They hadn't finished restructuring the IP entity, so ultimately there was about another $100,000 or $200,000 worth of costs that need to be paid. And one of the big ones that ultimately came out, the business itself, if it was sold and the entities wound up, would have produced about $4.5 million worth of tax. Under family law, not being a lawyer, I'm just going to do my understanding. Rosati's case back in 2004 has the principle that you only take tax and realisation costs into account if there's the expectation that the asset's going to be realised. And there's always issues in relation to, what is expectation to realise in the foreseeable future. So from that point of view, are they going to sell the business in short term? Husband was 53, 54, I think at the time. Now, although he talked about if it's too much, I'll just sell the business, he was on a journey. He wanted to keep this business going. Should that tax realisation cost be taken into account? $4.5 million. Clearly a sticking point when one party realises that should or shouldn't be in there. Other assets, superannuation, $1 million, that actually sold their family house at 1.1, and there are a couple of amounts that have been paid out. So excluding a business sale, $11 million, no business sale, $15 million. So quite a big range, which is right, which is wrong. The next thing to actually do is to actually work out, remember our little table showing the bits and pieces that we need to do. The next stage is to look at options for dividing it. So this is where we put it to the parties. Here's the two answers. All we can do is give you the information. What you do with it, and we'll help you with that, but what you do with it is your own process. So husband and wife go away and actually come up with some pathways. We'll do that with you, obviously. So wife went away and said, all right, there's the pool between 11 and $15 million. What can I do with it? Well, I'm going to come up with 5 different pathways. 3 of those pathways is that the business borrows, got no debt. So the business borrows either $1 million, $2 million, $3 million. What could we do with it? Or Nancy retains an interest in the actual business. So she actually doesn't sell out at all. So she holds an interest and continues to get a dividend over time. Or finally, she vendor finances the husband to actually buy her out. There was a fair bit of cash already held in the business because, again, it just accumulated. So each of those cases, taking $2 million out of the bank. The debt raised $1, $2, or $3 million. Whether there's tax on dividend 7A gets incorporated to a certain extent. Wife proposed that she take some or the majority of the super and the house proceeds and what she'd actually received to date. Plus there'd be a deferred payment. So that's the actual pool that she would actually take away. Now, interesting from her point of view, she went straight to the middle ground between the two net asset positions. And when she did that, she acknowledged that, look, maybe it doesn't need to be taken into account, but you know what? Ultimately, he'll have to pay it. So I'm trying to get a way forward that works. I'm going to go the mid-ground. And the husband said, okay. So it was just something, don't try to hide it, but in a table, we talk about it. Husband did the same process. And ultimately, we came down with quite a structured way forward, which partially involved, we're coming up to 30 June, the company paying for both of them certain amounts of superannuation in before and after 30 June and using their sort of payments in advance, the contributions in advance amounts, to actually increase the amount that was in superannuation. So essentially what came out, given their age, was going to be actually more beneficial to them in the actual superannuation environment. And a lot of that came out of the cash that was being held. They actually did succeed in actually getting cash raised more heavily used in that process. They raised about $2.5 million, and that was used in the settlement as well. We talked about the tax on dividends 7A. The husband actually retained a lot of the responsibility for this to be paid out of the cash flow of the business. They ended up splitting the super and the house, which came up with a settlement that worked for both of them. And what we try to do in collaborative is not necessarily come down to a percentage. We're trying to come down with actually a division of the assets and liabilities that is going to work for both parties. Not the percentage. It still has to, your family law overlay still applies here. It still must, as lawyers still need to provide the same advice to their clients they ordinarily would. But we're trying to come up with a process that actually works with the assets and liabilities that are there. Now, some of the issues that came up as we went, these are the issues we had to actually overcome. And this actually went on over a sort of bit over a year in time, once we actually got it all done. Time delays the husband's approach. He just stuck his head in the sand. So to actually get around that, we used the business's accountant, who was heavily involved in the business, and he was really good. So the husband would turn to the accountant whenever a decision had been made, and they worked closely together behind the scenes. So that worked. And often we do use the actual business accountant in this process. The business was losing the wife. We actually, through here, did the job description and sourced a financial controller for the business. So that person actually came in during the process and took over the role. One of the issues that came up from that was the financial controller then reviewed all the accounts and actually found an error with stock being double counted in the prior year, which was the valuation was done from. So we ended up having to, with incorrect financial statements, recast the valuation and the actual pool of assets from that. There were significant tax issues, and tax structuring was important. So the parties had already used an external lawyer, a tax expert, and we actually engaged that person to actually ensure that it was being structured in the most efficient manner. The funds to actually effect a settlement, negotiated with the bank and actually got the settlement through the bank, which was great, and an agreed pathway. The first pathway that was chosen, we had to change because of the incorrect financial statements. The second pathway that was chosen, when we reality tested the answer, it was just the sheer level on a monthly basis that the husband would need to actually meet was too restrictive. To the point where if there was a 3% downturn in sales, he wouldn't be able to meet the cash flows that he required. So we recast it to actually give him more leeway there, and we actually identified various assets that, if needed be, could have been sold if there was an issue. In this case here, there was a big 4-wheel drive that could be sold and create $250 in cash flow very quickly. So there's other bits and pieces they could do. So again, we created or identified a buffer that if something went wrong, that could be actually used. And interestingly, what happened after this settled is not long after COVID hit. So the business went really well. COVID hit, the business stopped its sales. So for a couple of months there, it was terrible, but a lot of you would have actually witnessed after COVID, everything went berserk. And for the drive industry, that whole area has gone mad.
Yeah.
And they've now got sales that are ridiculously at a greater level than what they were with their existing clients, but also identified new markets overseas, and the business has gone from strength to strength. But it was just a tremendous matter to be part of. And what got this across the line was the strength of the team. The parties were great, and they were extraordinary parties. Not without conflict, but the parties really helped. But the strength of the team was fantastic. We got some really significant issues along the way, but the team got us across the line. And we had to redirect a few times, but it was a really enjoyable project to be part of. So that's about all we have for today. We've answered those questions come through. So any more questions, please send them through and we'll answer them after the session. But any more questions afterwards, please email both Anita and myself. And if there's nothing else, thank you.
Yeah, thank you, everyone.
All the best. Cheers.